Welcome to another episode of Tangled Rights. I'm one of your hosts, Justin W. Wilson, Esquire.
And I am Shane D. Cox. Sorry for almost talking over you. That was just a problem.
Mr. Cox, I'm sorry for what I'm about to do.
This is an episode.
Not to you, but to everybody else.
Tangled Rights. We are attorneys, unlike some very negative commenters we've had recently. We run a law firm, a successful law firm in Las Vegas.
Is it? Yeah. We're successful?
Cox and Wilson Law.
Dude, that guy today said he had heard of me, and I'm like, dude, I have no idea.
What guy are you talking about?
The dude in the elevator, Kearns, whatever his name was.
I think he's a client or something.
No, he's an attorney.
Oh, okay. He had heard of us. So
he'd heard of me, and I was like, awesome. I hope that the story wasn't about what an asshole I am. Although that's probably true.
If it was
also,
accurate.
Quick shout out, Addie, for bringing these by for my kid. He loves cars right now. He's 18 months old today.
Did she get back from her trip, or where'd she get those?
I don't remember. She's got them.
Just coming in for.
But he loves cars. He loves cars. So yeah, that's what he does. Whenever he wants to watch it, he'll run up to the TV and he'll point at it and he'll just go vroom. Because he's only a year and a half, so he can't really talk a whole lot. He can say some words, but he can convey his thoughts, and that's what's most important. And 3+, so only be supervised to play with these because I don't want him to choke to death.
Yeah. No,
and if I didn't, then I would potentially be running with some child abuse, neglect, or endangerment charges, as I should.
Okay, well, we are two attorneys in the Las Vegas area. We're not trying to create an attorney-client relationship with you just by way of this podcast. Just always put that out there because we have rules and regulations and we have to be nice. We had a lot of negative comments last week. We just are ourselves here. Yeah, well, it talked about cops and interactions with cops. Somebody said that they were, not going to hire us as their attorney because they were looking for an attorney, and YouTube is the place you should search for your attorney. Yeah. I just think when I'm looking for an attorney for DUI, first search I'll do is on YouTube, right? Mm-hmm. Like, obviously. So, very interesting. We got a couple cases we want to talk about. We want to talk about a big theme today, though, which we'll get into in a minute. The first thing is everybody's talking about this Puff Daddy, Sean Puffy Combs. I think he was Puff Daddy when we were kids, and then
I think it was Puff Daddy first.
Then he was P. Diddy, and then just changed to Diddy. I don't know his name now.
Sean, whatever his last
name is. Well, yeah, I don't know what he goes by professionally, but we've had this theme recently where some people who are famous or prominent in Hollywood or, in communities, turns out that they are accused of crimes later on, when people are maybe brave enough to come out. I don't know what it is. I'm not the one that's
a polite way of putting it.
And maybe feel less threatened. Is that what you're...
Or when they're successful enough that the money's worth it.
Maybe that's it. Because P. Diddy's been famous and supposedly throwing these parties for years.
Well, that gets into a different thing where that's the argument. I was a comedian that made the argument. He said something about how this guy gets busted, but everybody's known about Puffy for 30 years and no one did shit. So it's kind of interesting when you look at it from that perspective because there's not only the detriment of being famous, but also potentially like, oh, hey, it's
well, it's obviously something that toes the line like a lot of being criminal or not, right?
Sure.
Because once these criminal charges are brought, they go through a whole trial for, weeks and weeks, and he's found not guilty on the big charges. He's found guilty on 2 charges federally, which are transporting for the purposes of prostitution, which are felonies and carry a 10-year sentence or potential 10-year sentence. I've seen experts say they believe that maybe he'd serve about 80% of the potential time, so maybe 8 years.
But he's already done what?
But he's been in, just about a year. Not a crazy long time. This went to trial rather quickly. It's really difficult. We've talked about this before, and we'll mention it again. Federal trials, you don't have a right to media there. So a lot of federal courts don't have this recording so we can really watch. So we get reports, and we're always wary of the news and the picture it paints because what they're incentivized to do is to get you to kind of be addicted to their product and keep reading. So sometimes they'll play it up as something, more interesting than what it really is. when you go and watch trials, a lot of people get bored by that because a lot of them are just fact witnesses. Like it's just not, it's not that crazy interesting.
I got a story on that. So it was when I was a prosecutor. I think it was my 4th trial, and I was doing it solo. So working late, getting everything ready. We're in trial, and it got to the phase where we're done with our case in chief. They're done with their case in chief, which they didn't put anything on, and they're reading jury instructions. And I'm literally sitting there, and it's like 38 jury instructions, and I'm just like nodding off. And I'm like, God, if I'm falling asleep right now, what is everybody else doing?
So typically, reading jury instructions, I'm guessing it works where the judge is just reading them to the jury. And this is the jury's not looking at them at the same time. The judge is just reading them off 1 through 38. And they're a paragraph each, I'd estimate, each jury instruction. Usually. So reading a paragraph about the standard, and they get delivered to the jury later for them to read. But you're mentioning at this time when the judge, you're tired from being in trial for so long, not a lot of sleep during those nights.
Been awake. Yeah. And then also everything that goes along with the trial. This guy, and they do it in a way that, and there's a purpose for all this. Like they have to make sure that they don't read it in a way that suggests that one instruction is more important than the others.
Yeah, like, hey, pay attention to this one. So it's kind of rote reading, just like real
a VCR manual.
Yeah,
it's the most boring shit you can imagine. And I'm sitting there and I'm just like, okay, I look through the jury instructions because normally I follow along, but I'm like, okay, this guy's going really slow. I read faster than that. That's my, whatever kicking in. And so I get through them and I'm like, all right, what am I going to do for my closing? Okay, my closing's good. I'm good. I know what I'm going to do. And then all of a sudden, I'm just like, man, I can't wait for this. Realized I was literally nodding off and I'm like, God, if the jury saw me. I'm looking at the judge, just kind of like out of the corner of my eye. And I'm like, oh, good, no one's looking at me. Thank God. Because if they saw me over there, just like.
See, that's the thing. Like, I know chewing gum looks like so disrespectful sometimes, chewing gum in courthouses. I don't know if you saw recently, there was a party that got in trouble for placing chewing gum under a table.
A lawyer?
It was a party, actually, that came with a lawyer.
Well, either way, they should get in trouble for that.
This was in federal court, and this just shows federal court how different they are. I won't use the word pretentious, even though I want to. The next parties, the AUSA, found gum under the table and reported to the judge. And so the judge put out an order show cause. Hey, who
put the gum
here? Why shouldn't I sanction?
Let's solve the mystery.
The party that was there before. And then the plaintiff admitted to it. Like, oh, I'm so sorry. I didn't mean to. And then the judge said, okay, I won't sanction you.
Sanction me.
Yeah.
Sanction me with your army.
Yeah. So this is federal court, and obviously this would be something in
you
federal
don't have
court
an
that
army.
happens.
Maybe you should shut the fuck up.
Well, they can sanction him and say you owe $500 or $200 or something like that.
It's just a line from Dave Chappelle.
I get you, but I'm just,
sorry, Mr. Cox.
Bring it into reality here. That's how serious federal court is. And while you're talking about jury instructions and how extremely boring they are and how long you're in a case, in this federal court, we don't get to just see the testimony. We're getting a secondhand narrative. The transcripts come out eventually, which is word for word, but doesn't have the tone, which is so important. Tone is so important in a trial. How somebody answers a question versus just a transcript is so incredibly different. Seeing a play versus reading a play, incredibly different. So we don't know for certain, like as we sit, how this testimony really was. We have a secondhand account of it, which that's why trials happen, is to get the, real accounts of things, not secondhand. So I guess I'm not surprised that he's found not guilty on some of these charges. They were saying that some of the testimony was
from the
outset. Little shaky on all this. The evidence was a little shaky on it. Did he likely to go behind bars for some amount of time? And he's young. He's fairly young. Like, he'll get out. I'm saying in the grand scheme of things, this is not the rest of his life, which he was facing, right?
No, yeah, he was facing life. Yeah.
So he'll get out and he'll again enter the world and probably not have this hanging over his head, right? No,
So what he ought to do, if
he's got to lay low,
if he does have the blackmail material that people are suspecting he has, he ought to. No one saved him. None of those rich and powerful people protected him. So he ought to smoke those fools. That's what I'd do.
I don't know what smoke those fools means, but okay.
Not kill them. That's not what I mean. I mean, like, turn them in, tell on them. They did bad stuff too, whatever.
Yeah, no,
and they didn't help you. They left you in your hour of need.
Just because you face criminal charges doesn't mean you're guilty. We're always proponents of that. Obviously, he was guilty of some kind of crime, which...
A jury of his peers concluded so.
By a jury of his peers, and he's acquitted by the same jury of his other crimes. So...
That's such a good... I guarantee you that all the money in his bank account, all of it, times 10, didn't feel nearly as good as...
Hearing that not
guilty on those life tales.
Yeah.
Because in federal, when they say life, they mean that shit.
Yes, they do. Those are pretty serious charges. We had Adam Clausen here, who was sentenced, 200 plus years, and that's what really, he thought he was facing. And then he turned his life around in prison, which is awesome for him. He was a great example of that and the rehabilitation that you can have. But yeah, what might be 10, might be 20 if they're run consec is what Austin read. But I think a lot of people consecutive back-to-back 10 years because he was 2 counts guilty of transporting. A Jane Doe even was one of the people he transported. And then
hopefully she wasn't a minor.
Yeah, I don't know about that. So it'll be up to the judge for sentencing. And you're talking about sentencing guidelines. Usually the federal courts have some kind of sentencing guidelines. I don't know if we know about New York in this specific district or not.
Well, I think the federal court guidelines are all the same.
Okay.
Let me see if I can find it real quick.
And we haven't practiced much in federal criminal court. The track you have is in state court, and that's where most of the crimes are charged. It happens to be in state court. Sometimes there are specific crimes that the DOJ wants to go after or whoever specifically. So this was across state lines. So that's one of the important aspects that made this a federal crime anyway. So,
well, it's non-binding, established in 1987 to provide uniformity, very precise calibration of sentences depending upon a number of factors. Not mandatory because they can result in a sentence based on facts not proven beyond a reasonable doubt, which is a violation of the Sixth Amendment. So the guidelines are advisory. They must consider them, but the district court must consider but not bound. They can depart. So it depends on the type of crime, which is a offense level, the criminal's history, and they add everything together, and then it determines the combined offense level. But I'm not seeing the actual guideline itself. I want to see, because typically in Kansas, it's a really nice little box. It's a grid, and it'll say offense level on one side, and then it'll say history on the other. And it literally, like, you go up to offense level and over to history, you bring it down, and it'll be in this nice little grid. And we can throw that graphic up. I'll send it to you. And it just says, oh, this is presumptive probation, this is presumptive prison, these are border box. In the border box, you get to argue. So that's the right to argue.
Okay. One thing I do want to mention, this is just recent news. This is from yesterday. Diddy, pending a trial, sometimes they'll ask for a bond to be released. He was denied bond, so he's going to be held. So that could be indicative of what sentencing might look like. It might be a little bit harsher. There was a side of, he has some danger. He has kind of a history, and
he also tried to flee.
Well, that too. So these were very serious charges. Even the charges he's convicted of are pretty serious as well. Like anything having to do with sex trafficking, I feel like we are taking very seriously right now.
Here.
There you found the table. So the judge doesn't grant him bail. He'll be behind bars pending sentencing. Usually those are quicker sentencing dates we've seen because let's say that he gets probation. Not that we expect that, but if you were to get probation, that's a sooner timetable for you to get your probation. So all that to be said, this is going to be in the hands of the judge. That is how sentencing works. Basically, no matter where you are, there will be arguments from the prosecution that, although he's not guilty beyond a reasonable doubt of these other crimes, he is a dangerous person. He has these other things. One thing I want to mention or ask Justin is a lot of people mention a trial tax. Do you know what I mean when I say a trial tax? So there's a thought that maybe judges will be harsher on someone because they pushed a case to trial. So they required more effort from the court. They required more effort from the staff, kind of thinking that the criminal defendant is the one that causes this, which goes against the Constitution. You have a right to the trial, but there have been some studies that show that judges typically will sanction somebody, will make the punishment harsher on somebody that goes to trial who gets the same kind of guilty on the same count as if they were to take a plea deal, which is not how it should work. No. In theory, in practicality, it shouldn't work like that. Although they'll cite something else that comes out at trial, right?
Oh, the facts are so egregious. Who knows what the judge is thinking? So I found something here that has a breakdown of what was talked about. Supposedly, the sentence the prosecution's asking for is 51 to 63 months, and the defense is saying that guidelines point towards a 21 to 27 month sentence. So even the prosecution, and this says, I'm going to read the exact quote. Citing the federal sentencing guidelines, prosecutor in the trial argued Combs should be sentenced to 51 to 63 months in prison, which is not great, but that's way better than 20 years. And that 21 to 27 months, plus you serve 75% of that, or 80% or whatever the sentencing stuff is.
Yeah, so sentencing is not even set yet. By the time this podcast comes out, it still won't be out. July 8th, they're having a conference to set sentencing and looking at October 3rd, but sometimes those things get pushed back too. That happens all the time.
Combs is facing dozens of civil lawsuits.
Yeah, no, of course he's facing civil lawsuits.
So,
and once he's convicted criminally, that can create automatic liability for those specific elements civilly. Yep. So that's another reason that some people will refuse to plead guilty to certain things is they don't want the civil liability. But if you're found guilty by a jury of your peers, that is automatic. Because Austin's question is, why don't they just sentence right then and there? And Justin, I think you are well equipped to answer this one.
Thank you. I know something.
Working on our transition and prepositional phrases because we talk over each other too much. I think both of us. Yeah.
I mean, me.
You too.
Me mostly. Internet person. Fight me. So the reason that sentencing typically doesn't happen the day that you get your guilty verdict, and I'm sure that there are exceptions as there are everything in the law. In Nevada specifically, you have to have what's called a pre-sentence investigation report or a gross misdemeanor worksheet if it's a gross misdemeanor. These are things that the Department of Parole and Probation prepare, which is a snapshot of your life. It shows your criminal history, your social background, how many tattoos you got, what your family life was, drug problems, anything like that.
Mental history,
and it's impartial. Although the way that they write those offense synopses up,
sometimes it feels partial.
Dude, it's like I read the police report. I don't remember that part, and I read it a lot because I'm the attorney. It seems like a little biased, but at the same time, the judge has to get everything when they look at it. Also, in the state of Nevada, victims have an opportunity to come speak, give victim impact at sentencing. So you simply just can't. Most of the time, because you've got all these other working parts. I think federally, victims have to have a right to speak in all states. I'm pretty sure, if memory serves. So a lot of times it's just not workable, right? Because there's things that need to happen because you didn't even know you were going to get sentenced because you haven't been found guilty yet. You get found guilty, there are steps that need to occur, and so you physically cannot cram it all into one day.
There's some trials that do require it, like death penalty. Those have to be determined by a jury. So,
but that's different.
But that is different. That's a specific, very niche, sentence that you're given that can only be given
by a
jury. It cannot be given by a judge. So there are specific things that are given by a judge. There are some trials where you're seeking maybe punitive damages, which are damages intended to punish somebody for real egregious acts, where the jury first has to determine, okay, is there a basis for punitive damages? And then maybe they'll go to a next phase of a trial. It depends on how the court sets it up. And the judge is in charge of their courtroom, and they get to decide how things work. But normally we'll see sentencing set later because there's a preparation for that. There's more factors that they have to look at because the judge doesn't have to know about prior crimes for the trial that they're sitting over at all times. But for sentencing, that becomes important. Okay, this is the 10th time that this happened or whatever it is. Then that would be an important factor to consider for their sentencing.
So this, I just did a quick research, and this is AI, so I don't know if it's correct, but I'm seeing sources on the side, so it looks like it is, or at least has some validity. This is saying Kentucky juries decide the sentence after a defendant is found guilty. It's probably not in all cases, but in major felonies, probably.
Sure, makes sense.
Capital cases, I believe it said that most states, and then non-capital cases like Arkansas, Missouri, Oklahoma, Texas, and Virginia, juries decide sentencing in non-capital cases. But that'll be a completely separate phase, as you said. But the point is that there are probably some states, a handful at least, where it's not just capital. It's like, hey, the jury gets to decide.
And I'm curious if
I don't hate that.
Me neither, but is it going to be the same jury or a separate jury too?
I think it's got to be the same jury because they have all the facts.
And that might be, they've heard everything and they know, hey, we were so close to not guilty on this, but technically he's guilty and we don't want the punishment to be that bad for him. So that makes sense.
Or they hear the mitigation stuff, like look at that case we just had where the kid stabbed someone on Fremont Street.
Sure.
He's been homeless since he was 12, right? There's all these other factors. He's 17 now. He was 16 at the time, addicted to fentanyl and meth. Like, I'm not excusing the behavior. It's awful, right? It scared a lot of people. It scared people that were watching. It scared a friend of mine, right? The guy with the camera. But at the same time, like, if someone was going to do something that's absolutely out of pocket, someone like that, right? So it's not forgivable, but understandable in a sense that like he's going to do wild stuff.
Yeah, but why would the jury be different than a judge for that? You know what I mean?
I don't know, because in that sentence we just stipulated, right?
But you have a range of jurors who are a lot different, I guess, than just one judge who's a crapshoot, which you've seen, you know, you get one judge and you're expecting prison time and you get a different judge for the same.
And you literally go, yes!
And you go, yeah, you're getting probation. Like,
and Bradford's JEA. But I think it's funny.
Well,
because we celebrate.
It is.
And then we mourn.
It's interesting. All right. We want to transition to the next topic.
Transition?
Yes.
Switching topics, are we?
We're switching topics.
Just like that.
I want to talk about DUIs. I've had a lot of questions about it because we started advertising DUIs pretty heavily. My mom saw it and said, "Whoa, what are you doing? Like, you know, driving your car and saying, oh, you got a DUI? Call us." So we've done a lot. I don't
know who's doing that. It ain't me.
We've done a lot of DUIs. We call them DUIs here in Nevada.
Driving under the influence.
DWI maybe in your state.
Driving while intoxicated.
There's different definitions. There's different punishments. I think this was topical because I saw an infographic, which Austin will put up here as well, that the 5 most dangerous holidays, 5 days that most likely to have a DUI driver. New Year's Day is number 1, which I think may include New Year's Eve.
I thought Thanksgiving was up.
Labor Day 2nd, Independence Day 3rd.
Oh,
okay. So another caveat that a lot of DUIs happen in the summer as well. And I think people are out later drinking. They go out because it's warm weather. They want to just go party, do good things. Not good things, but go out, party, drink late at night, get caught driving. So we wanted to talk about Independence Day. It's coming up. It'll be here tomorrow as we're recording. By the time we record this,
it'll be in the past.
It'll be in the past.
Celebrate America's independence by blowing up a tiny piece.
People drink a lot on Independence Day. Apparently the third most.
They pour libations when they celebrate.
Yes.
Neither of us drink.
So lots of summer DUIs, Independence Day being one of the big days. We always try and tell people, and I get a lot of negative comments when we post this. Why are you supporting people who drink and drive? Any kind of crime you may or may not have done, you deserve a defense. There are laws in place, and they're not bad laws. Laws against drinking and driving are good. People should not be doing this.
Correct.
But sometimes the state will charge certain cases that they shouldn't. We've had that recently, and I'll bring up an example here in a second.
Oh, you have a really good one.
And then there's some cases where the punishment just does not fit the crime either. DUI is something in Nevada which is an enhanceable offense, and most states have this where every instance of DUI, if you get a second within a certain amount of time, the punishment just gets worse and worse. So you have your license could be taken in Nevada. For a first, it's 6 months. For a second, it's a year, and then it just goes up. 2 years.
For a third, it's 3 years.
It could go up and go up. So you're losing your license. Your insurance is going up. We have something called an SR22 in Nevada. I think a lot of other states even have the same.
We have that in Kansas.
Definition SR22, where you have to pay kind of a penalty in order to have your license back. Anytime your license is suspended for DUI or for other reasons, you have to pay a penalty.
I've always thought that was interesting because it's through the insurance company, but the DMV requires it.
Yeah.
So you're paying more to Progressive or whoever. Really?
And
that company can make more money?
They make more money to insure you. Yeah. But you are a more costly person who might have more accidents, right? From being drunk.
But the insurance company doesn't require the SR22. The government requires the SR22 in order to get your license back so that you can use your insurance and drive and get around.
Does the insurance pay back the government for that?
I don't know.
I don't think they do.
But I guarantee you on some level, at some point, now it's just law. Oh, this is what we do. We don't think about it.
Right.
But when it first came into play, you're telling me, sober light of day right now, you don't think that some politician, either his campaign or he got a new house
or he had some stock in an insurance company,
or he got some stock. Come on, man.
No,
give me a break.
I'm not saying not. I'm just
like, as a former DUI defendant, and the amount of money that I saw had to go out for a .09 misdemeanor at 21 years old, right? The amount of money I had to pay, and I saw where all this shit was going. I'm like, bro, this seems weird.
It's a lot of places. We've said an average DUI costs a person 10 grand all in, right?
Well, I guess I got lucky.
That includes
70% of the average.
There you go. So a lot of people end up paying more. And this was a study from years ago before kind of the inflation of today. Attorney's fees, I think, have gone up on that. Insurance rates have gone up as well astronomically. So SR22s are going to be even more expensive.
Sorry to talk over you.
We'll talk about what a DUI is and what a DUI isn't. Here in Nevada, it is a DUI if you are driving or what we call physical control of a vehicle.
Actual physical control.
So some people might argue out of a DUI by having driven somewhere and then sitting in the passenger seat or the back of the vehicle. Okay. Their physical control is not a specific thing. It's one of those vague legal things that we can fight about.
Don't know what it is.
That attorneys
don't know how to define it, but I know it when I see it.
There's a ton of factors. One of them is if you are on a public road that only you could have gotten to if you were driving on a public road to get there. And then the second part of not physical control is where you are driving. Okay, it has to be on a public road or a private road to which the public reasonably has access. And then there's some definitions in law. Okay. The one I always use is you can get a DUI for being in a Walmart parking lot. That is a private area. We kind of think of them as public areas, but that is a private area that Walmart most likely owns. So if you're driving in there, the public has access to the Walmart parking lot. Walmart, in fact, wants as many people in their parking lot as possible because it gets many people into their stores. They sell more things, okay? So you can get a DUI by being on a public road. I think we all understand that, driving on a public road or somewhere where the public reasonably has access. We had a recent client, so we'll mention this one, a very nice girl who admittedly was fighting with her boyfriend, and to get away from her boyfriend, sat in her car in her driveway.
In Las Vegas in the summertime.
In Las Vegas?
Important fact.
It was in February. It was not straight in the summertime.
In Las Vegas where it's always sunny and a little warm.
It's still kind of warm. I think it was
cold.
It was cold. It was dark out in February. So started the car to have some heat on, was drinking her seltzer or whatever.
Mike's Hard. Or Truly's.
Truly, I think.
Truly, yeah, because it used to be Mike's Hard.
Not that it matters, right? Drinking while in her car. The car is parked in the driveway, okay? In the driveway. This is an important distinction because if you are parked on the road, you could be in physical control of your vehicle at that point. But she was definitively in her driveway as the police report came out. In Nevada, it is not illegal to be sitting on your private property, even if it's in a car, with the car started. It is not a DUI because you weren't driving. And you may be in physical control, but it is not.
Probably in actual physical control if you're behind the driver's seat and the car is turned on.
Yes, definitively, yes.
But the other thing to think about there that I think gets sort of lost, let's say you were in a Walmart parking lot, sitting in the driver's seat, just drinking. You got there somehow. But what the state's going to have to prove, and we had another case like this where it was in a gas station parking lot.
Yeah.
And they couldn't prove if he drove there or if his cousin drove him there.
Yep.
Right. So you're by yourself and you admit to the cops, yeah, I was drinking, drove here. Okay, you're screwed. But if you don't say anything, if you don't say a word, then they're going to have to prove that and they might fall short.
Yeah. So we'll talk about your example more. Back to mine that we recently had. We filed a motion to dismiss based on the charges. I expected when this client came to me, I expected the state would not charge it. They'd take a look at it and see, oh, where was she parked? Oh, at the house, in the driveway. State, for whatever reason, decided to charge it. That's sometimes what they do. There's oversight. They have hundreds of cases. Maybe didn't look at it close. We file a motion to dismiss. It's not the thing that we, want to do, but look, on a normal case. Yeah. We file a motion to dismiss and then finally they take a look at it. Sometimes you'll see you're just a number. Like if you're in the system, you could just be a number to the prosecutor. It's just a passing glance unless you have somebody that's going to take a closer look at it. And as soon as they were telling us this, when the client comes in, sometimes people tell us things and it's like, all right, like I know this is your version and I trust you. I know the police report's going to be a little different.
Trust but verify.
Then we get the police report and it's the same. And I'm like, yippee. Like, why did they charge on this? Like thought, oh, maybe this is different than what they're saying. No. So we file a motion to dismiss and then the prosecution takes a look at it and says, okay, you know what? Yeah, we
aren't even going to oppose this.
You're right. We're going to dismiss this. And I think there's a lesson here is why you need an attorney that's going to look at things is because you could potentially, have a defense attorney that doesn't look at it and says, okay, you got caught, you're 0.15. Like, let's take a deal.
And she was over the limit.
She was over the limit. And that's fine to be. You can be over the limit
as long as you're not driving. Control. The vehicle was on. But she wasn't.
They have to meet all the elements. Yep. They have to meet all the elements and where you are. And it's not like I was driving on a road and then I get into my, into my driveway. Then you're safe.
There was another important fact.
Which one was that?
And the cops put this in their report. I think they were
trying to bolster it.
I think they were trying not to charge it. Why else would they put what the husband said when they walked up?
I don't know.
He said, don't go anywhere. What does that mean?
That
don't go anywhere means you haven't left yet.
Yeah.
Right? So I don't know. I kind of view that as, maybe you're right, but I look at it as a cop saying, man, I don't want to do this. They have a prerogative here, or a directive rather, for what they're supposed to do with DUIs. And that's like, we've got a very low tolerance for that.
And it depends because you have your normal traffic cops that are rolling around that deal with DUIs. They got domestic violence police called who came out to the scene.
Right.
Because they're having a little fight. Somebody called in and, domestic violence cops come out who aren't as trained in DUI or not as specific. And the cops rotate teams too. They'll get different specialties, different trainings. It didn't seem like either of them had kind of the DUI training. Just the wording on their report was a lot different than what we might have seen in our DUI reports, which is fine. It can still hold water, but they just had missed the one important element of had to be on a public roadway or private to which the public reasonably has access. So we got that one dismissed, feeling elated about that. Nothing, no traffic ticket, no nothing. That just goes away. So that's great for that person. Not going to have any license implications either. Just the DUI's gone because of hard work that we did and looking at the case.
And writing a good motion.
And writing a good motion and having those, knowing the law and really looking at things. And we get excited over our success because it's our client's success too. So
yeah. And, I think lawyers are all the kind of people that want to win. You don't get here by being okay losing. And losing means not succeeding in your position. And it doesn't mean getting somebody out of a DUI. It doesn't mean, I made the community unsafe. It's the position that you have to take because it's your client's position. So you need people, I think, that are going to be invested on that level. Because like my dad always tells me, because when we talk about stuff, and he always kind of gives me crap about it, because sometimes I say we did this. We're going to sentencing. You aren't going to anything. My dad's been arrested a handful of times. I always told the lawyer that, we'll only do 180 days. He's like, we won't do anything. You'll go play golf on Saturday and I'll do 180 days. And it is kind of true, right? There is a bifurcation, but at the same time, I think the way to avoid those punishments and avoid the hyper negativity is when you have somebody who's going to take it personal.
Yeah.
And be invested.
And seeing their attorney get fired up, I think for some people that really works, like seeing you get really emotionally invested in some things because you get a little,
Me? Emotional?
Yeah.
Part of the problem is that my skin is basically transparent. And let me find one here. When I get good and mad.
You're not at the microphone, so nobody can hear you.
Huh?
You got to be at the microphone.
Whatever. So when I get good and mad or sad or happy or cold or hot or embarrassed or pick an emotion, this is what I do. I turn into a Christmas light, especially when I get pissed.
How many times have you told me that you thought you might be held in contempt by a judge?
Oh.
In the last year. Yeah.
I don't know. And I meant it like not as a joke, at least 6 to 10. But part of the problem is this.
That's what some people need.
I take the zealous advocacy thing seriously. And when I view something as wrong, like fundamentally, either on it doesn't pass the smell test, right? Like we got that DUI that we're going to get sentenced on. My client is going to get sentenced on, and he's going to go to prison. For his 6th DUI. I tried everything I could. I went to the box on every single thing I could do, and I got him down to the minimum because I argued to the prosecutor. The final thing I argued was that it didn't pass the smell test. He never got programming. He never got the options that are available under our statute to avoid the felony, to avoid getting lumped into the system that's just a cycle and repeat thing, because of a technical difficulty between California rules and our rules. And so I make that argument, and then he immediately cuts the sentence in half from what they, initially they wanted to do an RTA. I got him down to a 2 to 5, and then I got him down to a 12 to 30 month sentence, which is functionally an 8-month sentence. And he'll be doing that in a halfway house. He'll go to the fishbowl for 60 days, and then he'll go to a halfway house. So he won't even really be in prison. He'll go to work. And that, if I would have just backed down and took no for an answer, then he would have been doing 3 to 8. And been in prison, like real prison. Now he's going to be in prison, and it's a minor success, and I'm gutted for the guy. But he's jubilant. Like when I saw him today, he was so excited. He's like, thank you. You said you were going to fight for me to the end, and you did.
Yeah.
And it's a good feeling, but at the same time, I know that it doesn't pass that. You know what I mean? That smell test. It doesn't quite. There's something wrong with this situation, because I don't think we would have ended up here if he would have been able to get the benefit of the programming that's available for people have his problem.
Sure. And there's always two sides to the story. Somebody can, argue, and I know this client, I like him a lot too, that you just got to stop.
No, 100%.
Drinking and driving.
There is a percentage of this that is personal responsibility, because I'm an advocate of that. And I said it to him too. I was like, dude, this is another slap on the wrist. After 2 slaps on the wrist, you will not get another one. Next time they will hammer you. Please make this be your last. And he's like, no, I know. And I talked to him like that this morning. Like literally, when we get out of the courtroom, I'm telling him, hey, these are the things we're going to do. This is the trajectory of what's going to happen. I got all the things that you asked for. He's going to remove the scram monitoring. He's going to remain out of custody until his sentencing date, with the understanding that when the judge pronounces a sentence, he's going to put his hands behind his back, and someone's going to slap cuffs on him, and they're going to put him in jail and send him to
get your affairs in order. Yeah.
And that's exactly what it is. But he's also never once said, I didn't do this. Not my fault.
Yeah.
He's like, you know what? I screwed up.
Yeah.
And that's the worst. It's like that guy that I'm about to go to his parole hearing on.
Yeah.
That he was like,
that's the ones we feel for the most, that
because they own it.
Yeah.
He is. He's you get these people that they're whining, or they're like, oh, blah, 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 society. No, you chose. And he admits that he chose it. And it's like, how do you not feel something for that person? Especially when there's a gap, right? There's a gap that might have prevented this. If he would have gotten some programming, I don't know, maybe he would have done it anyway.
Sure.
But I can't unwind time. I don't have a Harry Potter wand, right?
Yeah.
But that's the DUIs are really, really strange ranges, right? Because his particular one, he wasn't he was driving and he wasn't doing anything erratic. Granted, he fell asleep at a stoplight. He wasn't even that drunk, really, in the grand scheme of things. For what you see, he was a 0.13. So they got him, he never fought. He was always, oh, yes, sir, no, sir, whatever. But then you see these other DUIs like Ruggs. And it wasn't my client, but the facts of that are horrible.
Yeah.
So that's why the laws exist, so that people don't get burnt to death in their cars because someone was going 153 miles an hour in a residential, right? That's why these laws exist.
Yeah.
I don't know. It is a very nuanced thing, and it is difficult because I've had people ask me that, like, especially, you go back home, like, oh, what criminal did you keep out of prison today? Like we're the prosecution's keeping the streets safe and we're keeping them dangerous. And I'm like, that's not how that works. Because the other big thing, and I wanted to point this out earlier, but I tried my best not to talk over you.
Thank you.
It's difficult because you plan most of this, so I'm reacting, and so I react. I don't know. I got a problem. The other thing that's more important than all of this, I think, is that the cops and the prosecution has to do things constitutionally correct. Skip the elements, skip all that. If they screw up, if they violate your 4th, 5th, or 6th Amendment rights, that's it.
It can be, right? Depends on what it is.
In my opinion,
yeah.
Like the Constitution is the bedrock for all this.
Yes.
If we didn't have that, the house of cards would fall over, it would turn to sand, right?
Yeah.
And so like that one we've got out in Nye County, we just did another motion to dismiss on, which I never would have probably done if you hadn't done that one, just because it's not the way I would do it. But now that I know it can work, it's like, well, they didn't have reasonable suspicion. So it's a 6th Amendment issue. And so, we filed a motion and hopefully it works, because in that situation, should I go through it or do you want to wait until later?
Oh, however if you want to see it through first, and then you can come back on it.
They get an anonymous tip, which is not an anonymous tip. It's some neighbor who's a jerk that doesn't like her. Calls in, says a woman driving has been drinking all day in a Chevy pickup. Okay. Cops go out. They find a Chevy pickup in a county that has 50,000 people in it, 60,000 people in it. And GM makes up 35% of vehicle sales in the country, Chevy being 23% of the 35. So it's a lot of Chevy trucks.
A lot of trucks.
Didn't say if it was a Colorado, didn't say it was Silverado, didn't say it was old school S10, didn't say anything, just Chevy pickup, didn't give colors. Well, the Nevada Supreme Court has said in another DUI case that I think it's State versus Sonnenfeld, anonymous tips are okay, but there has to be a level of specificity. And in that case, it was a bartender who's not even an anonymous tipper. It's just, I'm not telling you my name, but I'm the bartender at this place. So you could come immediately after the call and say, oh, that's Brad,
and
whatever.
I've seen this guy, he's drinking, he's drunk, and I know he's going to drive. Well, I know that's not safe.
More important than that. He called because it was a disturbance. The guy wouldn't leave. He was being rowdy, whatever. So he called him in to say, hey, this guy's being public disturbance, whatever. Well, then he calls back 5 minutes later. He just left. He was driving this color vehicle, this kind of roof rack, this direction, this license plate, this, and he's provided specificity.
So that's this is a reasonable suspicion standard to just kind of approach or make a traffic stop.
Because you're making the stop. And the deal here that's different, minor details, but more importantly, she didn't do anything. Once he pulls up to her, she's driving completely fine. Otherwise, he would have had no reason to pull her over. And that's the difference. And I understand that anonymous tips are valid and they do work, but they have to have a certain level of specificity. Crawford versus Washington, I think it's a Supreme Court case that talks about how the police officer with this anonymous tipper, if he comes in to testify, he's going to have to rely on what's essentially testimonial hearsay to get to why he pulled her over, which is a violation of the Confrontation Clause in the 6th Amendment to the Constitution of the United States of America.
So the Confrontation Clause is, let's just break that down just in case.
So you have the right to confront and cross-examine the witnesses against you. And in Crawford, if you are interested in any reading, it's quite a good case. And I really like the way they put it. I believe, and I put this in my motion, face-to-face confrontation is the bedrock, I think is what they say, of the system.
Yeah, something like that.
Something like that. And it's the opening line to one of the paragraphs, and that was the Supreme Court writing that, so it was probably obviously Scalia being so well put together.
Yeah, maybe. I don't know.
He's a great writer. Him and Ginsburg, both great.
I mean, we've moved to this video model of, having remote meetings with people, which you don't know what I'm wearing, what if I'm wearing pants, shorts, Speedo, whatever, below, right? Not right now. I was wearing them earlier.
He was. He sent me a picture. We called them budgie smugglers in Australia. You can look up what that means.
It's just okay. But there's been a lot of decisions now that are swinging back where in-person testimony is so important, and you have to have really good factors to be able to testify remotely. And it could be, convenience. It could be somebody sick. It could, there are reasons, but
for sure,
face-to-face confrontation, you can't really hide from somebody if you're, there. There's a different kind of thing about being face-to-face. One of the factors is it's so much easier to lie behind somebody's back. You'll say something behind somebody's back that you wouldn't dare say.
Correct.
In front of their face.
And
right?
You're not subject to scrutiny. But here's the line. Face-to-face confrontation is the foundation upon which the United States Supreme Court's Confrontation Clause jurisprudence evolved. And I really like that.
And that's what a trial is. Bringing somebody in that box, having the defendant sit there, see them. Am I going to say it, in front of them? And because all the rules are built to help criminal defendants. And that's how they should be. You could be facing...
Protect, not help.
Protect, right? Okay, sure.
Well, if you think about it from the perspective of what are we protecting from?
The government, which has...
The Salem witch trials, which has false accusations, lies.
The federal government has a boundless budget to go after you. We talked about experts last week. They can afford experts. They just have to get approvals and check boxes from somewhere and move the budget around and then, hire taxes somewhere. So they have a budget. They're like the richest organization in the United States is the federal government.
Yeah, and the most employees.
Just the most powerful.
And literally the most powerful organization on the human
could be coming after
human
you.
Existence ever.
And to make that equal instead of being unweighted on your side, there are rules in place to protect you and jurisprudence that's there to protect you. So the confrontation clause, having people actually who are going to testify against me, they have to be there. I want to see them.
You got to look them in the eye.
Look them in the eye. Be there when the defendant's there. Look at them. Identify them, saying that's the person. So that's beautiful in its own right because this isn't happening behind closed doors because secrets happen behind closed doors and bad rulings happen behind closed doors and lies and misrepresentations.
So in the confrontation clause in Nevada, I think we've got some good case law on it. Smith versus Smith, 111 Nev 499 from 1995. They held that a defendant's Sixth Amendment right had been violated because the prosecutor stepped between the defendant and the person testifying as a victim to literally block them.
During the whole testimony?
During the testimony.
Okay. Well,
so, and I agree with you. It's a little out there, but at the same time.
No, that's performative. They're trying to do that. Yeah. 100%. If you can show, and these are the kind of things that attorneys can think about and talk about behind closed doors, how to emote something or how to say something specifically at where I am in the courtroom when I say it.
But the reason I wanted to point this out is because it goes to what you said. The Nevada Supreme Court noted, and this is a direct quote, "It is always more difficult to tell a lie about a person to his face than behind his back." And so even if it's just in that moment when you're testifying, knowing they're in the room, if I can't see you, you're behind a curtain, but I know you can hear me, less than if I have to look at you. And I had to lie and say that those shorts looked good. Ding, 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 ding,
nice.
ding. Somebody's ringing the bell.
Good job. I wanted to talk about another one I think we've talked about before because you're bringing up, you have to have reasonable suspicion to pull somebody over. Mm-hmm. I was talking to someone and I was like, just because you're pulling out of a bar when you're driving does not give a cop reasonable suspicion to pull you over because you have to be about to commit a crime. And they don't know what your blood level's at if you're inebriated or anything like that.
Or if you even drank.
Yeah. Or if you
what
even
if you're
drink.
just there getting some sweet pretzel bites?
Yeah. Maybe some bars
or watching the game.
Locally have
playing darts.
Sweet pretzel bites with beer cheese. But
McMullen's over off Tropicana.
Yeah.
They have great burgers.
Okay. There are some bars with excellent burgers.
Yeah.
We've
gone to a bar.
We go to that brewery all the time. And
Nevada Brew Works. Yeah. Shout out on Main Street. And Imperial? Right? Is it Imperial?
Yes, it is.
Real good if you guys get a chance. And there's a barbecue joint right next to it to the north of it.
Yes.
We
got some good.
Portions are a little small, but man, that food is
good. Yeah. If you're a listener from out of state and you travel here, we'll take you to lunch. There's a promise from Cox and Wilson, Tangled Rights.
All 12 of them.
All 12.
Thank God we don't have so many listeners.
If
we were JRE, we'd be bankrupt.
Yeah.
Thanks, Shane.
Probable cause, reasonable suspicion to pull somebody over, because we had one recently that we talked about where the cop said that the tail light was out, okay? Or the light illuminating the license plate. And we got the video, and it turns out that that was not true in the slightest.
And he used his turn signal.
Was that something he had said? I thought it was just
so
the light.
Initially it was that the light was out, but then when he pulled him in, after he lit him up, he didn't use the signal.
Okay.
Which I think I'd be able to get rid of that anyway, because you can't light them up without the tail light. But the thing is, when you're watching the video, when it's dead on, you can't tell. Everything's so bright because, the cops, they'd get right up on you. But it was when he was turning, and we had to slow the video down. You can see the lights. You can, as the vehicle gets right to that 45 before he goes to 50 degrees, you can see the light for just a second.
Perfect.
Which means that the cop was
lying. I mean, there's some room for, hey, he was incorrect. Dumb.
He was incorrect.
Or incorrect. Yeah. But
that means he doesn't have reasonable suspicion.
There you go. And that's the important factor that we're looking for in our cases. Mm-hmm. You have to have reasonable suspicion, and these are the attacks that we can make. And then also blood, how they collect blood and breath. That is a factor that we've seen that they don't document accurately sometimes.
The homie or the cousin of our homie.
Sure.
Should have been a DUI second.
Yeah.
Every single thing about it was right. But I run it through the same checklist, and what do I find? They didn't list the times.
Nope.
It checked that they did it within 2 hours. Okay, cool. What was the time? I can't say. Okay, well then you cannot meet your burden beyond a reasonable doubt, because it is a reasonable doubt that you got it wrong. You didn't write the time down because you wanted to make sure you did it right.
And we talk about these successes. Sometimes people come in and we're like, oh, cops screw up like a lot, right? They do, but
they're just like me and you.
But not even most of the time. I'd say most of the time they are doing their things exactly because they get training on this. If something goes wrong, if something goes off, sometimes the prosecution can reach out and say, hey, let's train this guy up on this specific thing specifically. So, next time everything looks good. Most times the cops are doing what they should do. Sometimes it is just we're working on talking about your good factors to communicate to the prosecution saying, hey, just an accident, aunt just passed away. Sometimes we see these, they're having issues in the house that are, affecting them. That's the only reason that they even decided to drink and drive. It's not a common thing for them. So you want somebody on your side. If you happen to do this, I always want to tell people, don't drink and drive. Just call the Uber, call the Lyft, have somebody drive you. It's not worth it. Just make the right call. But sometimes you make mistakes. People make mistakes all the time. And when you do, you need somebody on your side.
Correct. And to kind of put it into legalese, what reasonable suspicion is, it's where the police want to briefly detain someone to question them based on specific and articulable facts. Meaning articulable, they can explain what it is. It's not like, oh, I feel something. It's, oh, this guy did this, and that's what makes me think he may be involved in criminal activity. Lower cause or lower standard than probable cause because it's not to arrest. It's just for a temporary detention, right? But it has to be based on concrete details and observations that led them to suspect criminal activity. Unusual behavior, furtive movements, matching a description of somebody, things like that. It's not a random feeling. It's not a hunch. And it must be objectively reasonable, right? Anybody would think the same thing, not the cop did. And it only, again, allows for a temporary stop, but not an arrest. It's just detention. It's very limited in scope.
Yes.
And from that...
To give a ticket, ticket usually is what it would be for, right?
Usually.
Give a ticket. They can ask you, hey, can I search your car? Don't do it. Don't talk to them.
Oh.
Be short. Be curt.
Be polite.
That's okay. Be polite.
Austin says, quote, fuck you. It's not.
All
is
right.
it advisable? Sorry, about to lick a boot here. Probably not. Why? Why is it not advisable to do that?
To do what?
Fuck you no when a cop asks you if you can search your car.
Because they just get on edge. And do you want to spend a night in jail to be right? Just shut up.
Depends. Do you want to squat and cough in front of another man, Austin?
Do you want to
maybe he does
have your private parts searched? No, I don't.
I'm not going to search it physically. At least the times I got arrested.
Whatever private parts means for you, the squat and coughing,
That's not private for Austin.
Sheesh. All right, I'm going to move to our listener question.
You got to ring the bell now. We got 2 bell rings.
I'm going to move to our listener question. What could ruin a personal injury case for the person who is injured and not allow them to get any money? big factor here is there is just no collectability. That is the big problem. There are more people driving uninsured right now than ever before. The rates are so damn expensive. Because the rates are expensive. We talked about that. We encourage people always to explore uninsured, underinsured motorist coverage. We had a recent case we signed where, that is going to be the collection for this person that is so needed. This person's really injured.
Catastrophic injuries. Nearly died.
Exactly.
Life flighted, brain bleed.
Yeah, all these things. So just if you can get underinsured, uninsured motorist coverage, that would be one reason why a person would not be able to collect is the person that hits you, it's because they don't have any money, that they don't have any insurance. So you're not going to be able to see a nickel or dime out of them. Can't squeeze blood from a stone. Okay.
What can they do? Like, what can a person do to screw it up? Yeah. Okay. Well, lots of things. You could lie to your doctors. You could use methamphetamine and fail your drug tests from your pain management doctor. You could have, and this sucks, but it's the truth. You could be what they call a litigious person, have 20 lawsuits. And it's not just bad luck. The people that I'm talking about, you can kind of tell.
That could just hurt. Yeah.
Yeah. But also you could fail to go to doctor's appointments, right? Like you're saying that you're hurt, right? And you need to get better. And lawyers obviously are not in control of this. All we do is point you in the right direction. We say these doctors, if you don't have health insurance and can't afford it, these doctors are the kind of doctors, again, do not care which one you go to. I would not send somebody to somebody that I know is a quack. When I say send, I mean point the direction. Hey, you can choose which of these doctors to go to based on scheduling or location or whatever. Google them, find the reviews, don't care. These are the ones that'll treat you on a lien. What that means is it's an IOU. So you get paid the doctor after the lawsuit settles. They get it from the settlement proceeds. That's really who should be compensating the doctors and not coming out of the pocket. Not doing that. Like you're saying you're hurt, but you're not going to a doctor, so no jury is going to believe you. It makes it very difficult to recover, right? We've got cases like that. We were just talking about one today where crazy crash. Totals a brand new 4Runner and didn't treat that much. And so, it's like, especially if they have an expectation. With this client, it's not a big deal.
Yeah.
Very chill, no problems. You get clients that come in here and they ask you what the policy is. You tell them, it's a 100, 300 policy. So we're working with $100,000 of insurance coverage. Okay, well, I want that 100. Great. But you only went to the chiropractor 4 times. Hard to sell, right?
And it goes back to everything we talk about. There's always two sides to a story, correct, right? So the person that, hit you or caused the accident will say, you're barely hurt. You only went to the chiropractor a couple times. You don't deserve $100,000. I don't think my insurance should pay that out. So we are creatures of seeing things through our own lenses, right? Mm-hmm. So if we hit somebody, we're going to say, they're not that hurt. It wasn't that bad. But if we get hit,
hurt me and I was.
If we get hit, then we're gonna think, oh man, I really deserve a lot. So it all comes back to expectations. I really do think people should seek attorneys on this because it is a complicated field. We talk to people who have never done personal injury and they don't know the details and the ins and outs of it. And there are particularities. It's not a crazy complicated field, but you do need to learn things.
And this is a particular thing that ties into what you asked about what they can do. Not getting an attorney initially because whatever reason, but it turns out you're more hurt than you think you are. You miss that investigatory time. And let's say it's a he said, she said, right?
There's evidence that lapses.
There's evidence that goes away.
There's video that disappears.
Do you know how long 7-Eleven keeps their footage usually? Most of them. They don't all do that. Some of them, it's like 72 hours. But a lot of them around town, it's a week. You have a week to get that video. And if you don't get it, it's gone forever. And if someone said, I had the green light, but you really had the green light and this video shows it, guess what? Now we might not be able to prove it. And let's say you're just a shifty, kind of shady type person, just how you talk. Like you're nervous, you're not good at public speaking, you can't, you don't have that assertiveness that says, hey, I'm standing tall and I'm telling the truth. I know I am. You're a meek person, right? Let's just say that was the case. And the other guy is the opposite. And so when you put those two people in front of a jury, he can't even look at us when he's telling us he got hurt and he had the green light. This guy's like, no, I'm certain. I'm 100% positive. Here's how I know. Blah, 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 blah. You lose. But you were really right. If you had an attorney, that wouldn't happen.
Potentially, right? Boom.
Because we like to investigate.
All right. Thanks for stopping by for another episode of Tangle
Celebrate
Rights.
the 4th of July. Please
don't drink and drive.
Keep all your fingers. If you did drink and drive, because it'll be later, give us a call. We'll help you out. We'll make sure the state is held to their burden and that they didn't violate your constitutional rights. If they did, we'll go to bat with you.
And protect your confrontation clause because you like confrontation.
Don't talk to the cops.
Peace.
But also don't tell them to fuck themselves.